thought of a retrial or a second bite of the apple where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we know is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed, and I trust your wisdom on that.
Leads to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well, here, it is, as they pointed out, they're the losers in this. And they are prepared.
How can you be sure? You just don't know. You don't know.
Well, one people, one of you do everybody doing good as always. So day one of the 2-day appeal for Vybz Kartel in the UK at the Privy Council has come to an end. And we're live for around a couple hours. So if you want to watch the full live at the proceeding, a link I got in the description box. But right there, so we'll kind of summarize everything and make you know what go on. You see me? Yeah. But before we get into the details, just press on the like button. Very important. Help out the video, help out the channel. And YouTube can push it to a larger feed. You see what I say? And if you're new, just subscribe. Said we. You see me? But we are getting at the details. So, and day one now. Day one was basically just a kickstart proceeding, but a whole heap of talking go on. You see what I say? Yeah, not the typical court where you used to like judge and knock the hammer and all of them something there. I guess the UK court more civil. I don't know. But yeah, it was an interesting day. You see what I say? Vybz Kartel lawyer Buchanan went on the stands, and me I make you hear what him say, is what I say, and then we are gonna talk some more upon it after. So
Mr. Buchanan.
If it pleases the court, Lord and ladies, I just wish to make a point, a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones, and this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings. The concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my Lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true, and then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman, and more conversations about her role, and so the taint or the poison would have gone back as far as November in a 65-day trial and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked, what their responses would have been for the judge to make an informed decision. And I say this in the context that, in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso unjust. It's just not possible. It would be an absurdity in the law. Now, in relation to Lady Simler, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time it was presumption of constitutionality, and certainly the onus was on the appellant, to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that? Lady Simner would have asked, is that the judge now has a duty to carry out the Oakes test, or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did, at first instance, to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is
right?
Correct.
Was it preceded by some sort of review or report?
My learned friend, actually, Mr. Salty Casey actually made mention of the review and the report.
Oh,
but
right.
what is significant
Check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this, and I'm quoting, I'm paraphrasing our Chief Justice, and it's found, thank you, it's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society. Yes. Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of circumstances in Jamaica, or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21. Yep. But what's significant is that what is clear is that there is, similar to in the Canadian jurisdiction, that the test, which is the demonstrable justifiable test, is mandatory once once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us rather than imposed from outside.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b. It is the last flicker or shimmer of light to what it is to be a human. And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it. So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, because and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time, or
well, you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. but the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, the lawyers and the lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned, is tainted, was allowed to remain on a jury, to bring a verdict, simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror ought to have been removed to protect the fair trial right. And it is in that vein that I will say that there is no cure, no proviso, or no thought of a retrial or a second bite of the apple where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we know is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed, and I trust your wisdom on that. Thank you.
So basically, what I must say right there so is that with everything that transpired during the trial, the tampering of evidence, the jury that tried to bribe everyone, with the judge knowingly, no one said that go on and still use him, all of them something there which contribute to Vybz Kartel not getting a fair trial. With all of that put on the table, there were no consideration of a retrial. And with all of them evidence there, the tampering of the text message, the video part and all of them something there, Buchanan say, yo, because them never offer a retrial, him feel like say, yo, all of this will squash. You see me? Yeah, just let them out, let them be free, because them never get a fair trial in at the beginning. Hence the reason for the appeal and all of them something there. Yeah. So wanna think about all of that. Wanna think about him first statement. Want to hear your thoughts on this in the comment section. Anyways, the person now representing the Privy Council now, him basically argue say, yo, Vybz Kartel them did get a fair trial. The judge did do what him feel was best in the situation, because with all of them something considering, they were long ahead in the proceeding, I think around 54 days in the court hearing. One of the longest court hearing in Jamaican history. And the judge basically do what him feel was best in the situation, because them never want to go back over another 53 days. You see me? But anyways, I'm going to check out Fime's statement now. You see me? And the Privy Council's response. So check this out.
Tell them to abide by their oath. I think my submission is a separate question.
Yeah, the way it's put in Putnam is a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, I was trying to go by the Putnam test, consciously or unconsciously. Is that something which was going to be in the back of their minds, come what may? Now, on the first question, namely, you've got one rotten apple here, so that's it. We say that can't be right. We have in our written case drawn attention to the case of Brown, which is in the electronic bundle at 6329, paragraph 31, where a not identical thing happened, but the problem arose, what is a judge to do? Or rather, the point was made that the defendants cannot derail trials just by making offers of bribes to juries and so forth. It's not on all fours, but I submitted it important all the same. So it's 6329. And it's paragraph 31. We fully understand any judge's reluctance to discharge a jury in circumstances for which a defendant bore material responsibility, although there are no doubt gradations of responsibility, starting with deliberate misconduct by a defendant aimed at achieving a discharge in circumstances where a trial is going badly, or at achieving a favourable verdict and ranging downwards in seriousness from those situations. Counsel for the appellant thus, rightly in our view, accepted before us that it cannot be open to a defendant to obtain the discharge of a jury by deliberately creating some ground of aggravation or discord between him and the jury, whether inside or outside court. But in order for a judge to rely on the appellant's responsibility for events occurring as a ground for not discharging a jury, the circumstances giving rise to such responsibility must, it seems to us, either be agreed or ascertained by the judge to exist. They cannot be assumed simply as a prima facie case. Now, that's not on all fours, but I submit the basic point is this. It's not open to either a defendant himself or indeed a juror acting, if you like, without instructions from the defendant, but nonetheless in the defendant's interest to derail a trial. And I submit that's an important point, and I submit it also goes to the whole jury system. And it will bring the jury system into disrepute in a case such as this. If the position is really this, there are 10 innocent jurors who have performed their duty, let's assume for the moment, who have performed their duty without any shred of bias. It would bring the system into disrepute if the verdict is nonetheless to be set aside because of the one bad juror who was not obeying his duty. I submit that would be, one can understand what you might call the purest version of that. One can understand, of course, the notion that a jury has collective responsibility. But in my submission, that would be would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you'd get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
But I think, my lords, I'm bound to accept that we don't know, of course, but obviously what concerned the judge is, I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
But what I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. And they are prepared...
How can you be sure? You just don't know. You don't know.
Well, my lady, funny enough, we do know in one sense, because it was a 10-1 verdict, and we know from evidence acquired afterwards that you-know-who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funny enough, the defence afterwards.
Yes, but if there's a... Well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If the jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have who knows, it could have inclined them to dig their heels in and prejudice them against the defendants.
My lord, I agree. That of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten...
See people, so I get to hear from both sides now. Is what I say, and based on how it look, it would have seems as if the ball there in a Vybz Kartel court right now, and him co-accuse them. You see me? But it's still not enough to kind of overrule or overturn the whole decision, because there's a whole nother day left. You see me? And them not touch upon the communication part with Digicel, the tampering of the text and the video. And all of them, so them not touch upon that yet. But based on what them address in terms of the jury, the bribery, the decision to still continue, even though them know say one of the judge try bribe the other 10 jury them. With all that considered, you can definitely hear some rebuttal from the Privy Council say, but is that ethical? Him really do that? And basically I question the judge action. You see me, people? But yeah, I feel like it was a good day for Vybz Kartel and him co-accuse them. Them resume tomorrow, I think around 6. We'll go live again. You see me? So you can tune in and always, and definitely want to hear your thoughts on this in the comment section. You see me?